we're down to two this afternoon, as you can see. Our colleague is unavoidably having to go somewhere else. Yes, Mr. Henry.
Thank you, sir. There are two issues. The first is the continuing and inexcusable delay in delivering compensation to the wronged, to the innocent, and that will also include whether the awards proffered are even remotely approaching acceptability. The second, which is inextricably entwined with the first, is whether POL will accept that it deliberately denied, obstructed, and delayed appellate rights, needlessly, unjustly, and wrongly prolonging the suffering of those that it had devastated, either by civil judgments and bankruptcy or criminal convictions. Wholly unjustified, iniquitous prolonging of suffering, which, without exaggeration, you might even compare to torture, because these are people who were destroyed by the legal system. As Professor Moorhead, in his evidence before you, expressed as long ago as February, his concern that this tragedy, these appalling injustices, had been facilitated and perpetrated by legal services. And to deny people their Article 6 rights, both as to contesting the charges against them, and that is beyond question, but then to suppress and bury the very exculpatory material, the very information that would allow them to go before a court and say, I was wrongly convicted, this judgment against me ought to be set aside, is a degree of wrongdoing of such magnitude that it is without precedent. And Bayes is also, as we have submitted, responsible. And we come to the buzzword, the slogan, full and fair compensation. Well, of course, sir, as you well know, no amount of money can right the wrong, undo the harm, and heal the wounds caused by these terrible events. Terrible is indeed a strong word. But it almost becomes an understatement, sir, if one adds to the appalling injustice of wrongful conviction or wrongful civil judgment a deliberate and malignant desire or policy to suppress the truth so that even the senior courts are deceived, so that these appellate rights, which are sacred in our system of justice, were effectively destroyed for years. Now, an integrity test can easily be determined by POL's approach to these two questions. First, did the Post Office deliberately interfere with or obstruct convicted defendants' rights of appeal? Second, if so, was its purpose in doing so improper? And, sir, I invite you now to ask Miss Gallifant those questions, because although she has submitted this morning that she does not wish to address them until phase 5 of this inquiry, these awards are going on now, and there should not be any further delay, such as the delay, for example, in argument that was expressed in Hamilton that, oh no, you don't need to deal with ground 2 abuse. Let ground 2 abuse be resolved in the malicious prosecution hearings, the malicious prosecution claims. And the court robustly, albeit belatedly, but robustly rejected that approach. So, if I may, sir, with your permission, I shall sit down and give way to Miss Gallifant to answer those two questions which arise from the argument that has been posed, because it is important that they are resolved as soon as possible and that there should be no more pettifogging or equivocation on the matter, because this goes to the actual gravamen of what is under consideration here. The wholesale contamination of civil and criminal justice by a private prosecutor who had a trusted reputation, was a public corporation, and historically an arm of the executive. And such inequality of power, such a disparity in status between the unfortunate agent and the oppressive master allowed this to happen before 37 Crown courts around the country. 37 Crown courts involving over 700 people over a 20-year period. And that is why, sir, it ought to be resolved right now, without any more delay, dilatoriness or prevarication. And so, sir, I ask you to invite my learned friend to answer those questions. Deliberate interference for a wrongful purpose.
Well, I'm not going to make any kind of direction, Mr. Henry, as I'm sure you appreciate. Whether or not Miss Gallifant wants to say anything is a matter entirely for her at this stage.
Thank you, sir. No.
Well, that may be a matter of profound regret. Not, of course, for my learned friend who acts on instructions, but it may be a matter of profound regret. And we shall see, by their fruits you shall know them, sir. We shall see whether this is performative breastbeating or an actual realization of the enormity that has been done. And before addressing in particular the pernicious effect of delay, I want to come, if I may, to a central premise of the argument as to why we submit that deliberate denial of appellate rights for a malicious and malignant purpose is a live issue here. As the CCRC noted, the Post Office's attitude towards disclosure tends to prove that the intransigence identified by the Honourable Mr. Justice Fraser in the Post Office's conduct of the Horizon litigation beset the manner in which they conducted criminal prosecutions. It was as a consequence of an ineffectual GT Grant Thornton report commissioned by the CCRC, which relied on the transaction logs, that the CCRC then decided that that report was of little utility and they would have to await the decision of Mr. Justice Fraser in Horizon number 6. The transaction logs themselves, sir, would not reveal the bugs, errors and defects which would have been apparent from the ARQ data, and of course they were not aware of the peaks. And so therefore at paragraph 47 of their statement of reasons, they decided that they would have to await the Horizon litigation, which they then described as revealing a fundamental shift in understanding. Now that is why, sir, we went into exhaustive detail in our document on compensation on the extraordinary, almost unbelievable conduct of that litigation, both the common issues and also the Horizon litigation. Because, sir, it appears to be, again, inextricably linked to the issue of openness, transparency, and candour. And those criminal appeals in Hamilton and others were literally hanging by a thread on the resolution of Horizon number 6. But I now want to turn to the pernicious effect of delay in relation to a convicted individual, leaving aside for this moment, of course, that two of those with Miss Page and Mr. Schwartz we are proud to represent, Miss Arch and Mr. Castleton, were never convicted. Never convicted. But let's deal with a conviction. First of all, which would be common to Miss Arch as well, the unjust shunning and suspicion after they have been dismissed and the rumours circulate, the gossip about they've robbed our pensions, they've robbed our granny's pension. The wrongful dismissal, the use again of the law to dismiss them. The criminal conviction that followed wholesale breaches and utter dereliction of the Criminal Procedure and Investigations Act, the duty of disclosure, the Code for Crown Prosecutors, the Attorney General's guidelines on disclosure, where the private prosecutor, who should act still as a Minister of Justice, particularly when they are a public corporation, acted as an unscrupulous, ruthless, and remorseless party. Incarceration. Then the unjust judgments that follow. I now actually involve those who are not convicted. Unjust civil judgments, bankruptcy, unjust property seizure, damages, confiscation, compensation to poll, all based on entirely fictitious, utterly baseless computer-generated losses. The ruined health, both mental and physical, the intractable stress-related illness, autoimmune disorders, PTSD, the impaired and shattered earning capacity, the fact that you don't get a job because, of course, under the CRB and then the DBS, these matters are disclosable. You are effectively a convicted person, even though you are completely innocent. The pensions contributions that have never been made, the national insurance contributions that have not been made, and then the loss of perhaps capital, undoubtedly, both sunk into businesses and also in property, replaced by poor housing caused by one's reputational damage, consequent as well upon one's loss of liberty. Now, I've dealt with those in the abstract, the generic. I now want to transpose them onto a living human being who is here today, Janet Skinner, who was, from the time she started at the post office, really the darling or the pet of the post office back in the early 1990s, and did phenomenally well and was respected and liked and admired by all of her colleagues, and then had it all taken away. And of course, you know that she was charged with theft and false accounting. She was advised that on the strength of the evidence, in inverted commas, she should plead guilty to false accounting, and did so in the hope that she would not be sent to prison. But of course, she was. As she walked beside me today, she nearly stumbled and she limps. And I asked her why. She has nerve damage from cervical vertebrae 4 downwards. She has neuropathy from an autoimmune disease that struck her down in 2008 after she'd been released from prison. Is it just a coincidence? Is it too remote? Is there going to be some clever legal argument about causation? Some novus actus because some virus descended from the North Sea and landed in a cup of coffee in her house in Hull? Who knows? She was told she was never going to walk again. She limps and will always limp because of it. Her house was repossessed, but fortunately, she secured a sale. But when she was released from prison, she couldn't find anywhere to live. So she had to live in condemned housing. Condemned housing. With her then 14-year-old son, Matthew, who is now 31, her 17-year-old daughter, Tony, who is now 35, living in condemned housing. Those two children traumatized by the fact that their mother, as I said to you, refused to see them while she was in prison because she did not want to see them, and she, more importantly, did not want them to see her in prison garb. So she could get nowhere to rent, and she hasn't worked because she can't work since 2008. Now, the emotional trauma visited on her children, will that be compensated? The fact that they were living in condemned housing with their mother, the fact that they were traumatized by the fact that their mother was taken away from them when one was 14, the other 17. They're now 31 and 35. They were asked to compose statements on the effect of this upon them, and as they did so, they wept. The trauma attenuates across time and space, and it doesn't go away. It doesn't go away. As Janet Skinner said to you, sir, in the impact hearings, no amount of money is going to make this better. These people have been changed. They have been changed in a way that not even you or I can see, and one knows from medical science that that is right. That stress of this profound nature, trauma of this profound nature, actually affects people at a cellular level. It is now beyond question that mitochondria, which are the actual driving force of human existence, providing energy and communication, are badly affected by stress. And that is why, sir, it is not a coincidence that in the whole history of this saga, you have people who have already died, who have committed suicide, and who all have, as a group of people, an unusual incidence of physical and psychiatric health issues. And that is because of the appalling suffering to which they were needlessly subjected, but more importantly, in the context of this matter, it was inordinately and wrongly prolonged. Now, with great humility, sir, you will realize that not even with the powers vested in you, you don't have the power to do anything to right that wrong. Your duty is to the truth. But these profound wrongs have affected these people in ways that we may never understand, and which also may not be legally recoverable, which is why one really does make this submission that full and fair compensation should not be a box-ticking exercise going through a taught textbook, but should actually reflect upon that vital question: where would these people be now had they never suffered this appalling injustice? that the trajectory of their lives had not been flattened or crushed by false accusation and then the denial over many years of a right of appeal. And that is why I really adopt Mr. Maloney's point that, yes, the official receiver can devour an award, but there wouldn't be creditors if these people had not been branded, shamed, convicted, or otherwise destroyed in this inexcusable manner by Britain's most trusted brand. That is what full and fair compensation requires, sir. Not that the official receiver, the trustee in bankruptcy, takes that which is owed to the creditors, but to ask oneself why Mr. Castleton, who sank so much money into that business, who had had a distinguished career serving his country, then in the city, and then decided that he wanted a change of pace in his life and would become a sub-postmaster, ended up being bankrupted, ended up being shunned, and as you heard from me when I made an opening statement, the atrocious degradation and cruelty shown to his child, his daughter, by those who thought that they were better than her because her father was a thief. As I've said, the damage is extraordinary. Like a stain, it spreads. And it was not contained for over 20 years. And it may never be eradicated because of that. And that is why the full measure of damages is required and justified in affirmative answers in due course from the Post Office and the Paymaster Bays to those two questions that have been posed. Those two questions, simple questions, sir, simple questions which would reveal so much if they were answered, as opposed to that silence. Or your question earlier today, sir, where you were talking about artificial obstacles. You didn't use the word pettifogging, but the unnecessary bureaucracy. I mean, that might have been necessary if there was going to be a fight, you said. But did you get any categorical assurance from those representing the Post Office? Oh, no, there's not going to be a fight. No, you got this. It's unlikely. We're not here to deal in likelihood, sir. We're here to deal with redressing the reputational damage, the mental health and physical health that has been scarred, the future earnings that would have been missed, the opportunities that could have been grasped that never were, and all unnecessarily prolonged by a decision at the highest level that they would rather preserve commercial and reputational matters as opposed to doing justice to the victims. As you saw, sir, the Post Office was receiving advice on compensation from the same Mr. Simon Clarke, who wrote the Clarke Advice, in 2013. Why did it take a further 7 years, 8 in fact, before the resolution by the Court of Appeal's judgment, for the matter to be put beyond question? Why, in the interim before that, was there that tooth and claw last-ditch stand before Mr. Justice Fraser in those 2 trials where some extraordinary events occurred which need not trouble us now because, of course, they're in the forefront of your mind. So I want to conclude, sir, by thanking you for arranging this hearing, requiring Bayes and Poll and also the UK GI to appear before you, and for Bayes and Poll to answer your questions and explain what they claim to have done in resolving this issue of compensation. But I still come back, sir, to those two questions which have not been answered, and they will be the test of whether this is more words, words, words. Words, 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 which you have read last night, and words, 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 which you have heard today. But still, some of the submissions heard this morning have the capacity to amaze. I mean, what parallel universe does Poll inhabit when stating that the lack of a formal scheme has been no impediment to the settlement of pecuniary losses? How so? Particularly when Miss Felsted waited half her life to be cleared and had to wait until the 19th of October to have the unjust confiscation order made against her back in 2002 repaid with interest. So from the 23rd of April 2021 to the 19th of October 2022, that was not settled. And it is interesting to note, sir, that she had been convicted on the 26th of April 2002 and had to wait until the 23rd of April 2021 to be vindicated. But I return to her, Miss Skinner, and also Mrs. Misra. And with Mrs. Misra as well, I would wish to say a few words now about the extraordinary suffering that she endured together with her husband and children. Let us not forget, sir, that from 2005, they were trying to make their business work. In 2010, after sinking family money into the business to satisfy wholly fictitious shortfalls, she was sent to prison, pregnant. From 2010 to 2021, she had to wait, like Miss Felsted and Miss Skinner. And it is now nearly 2023. And of course, a claim has not yet been submitted in her case, but it is that long delay before her name was cleared that is a matter we respectfully submit that ought to be taken into account. The impact on her children, the impact on her husband who descended into alcoholism. Families get ripped apart. Those who would normally be sometimes the people to whom one would seek solace and support become ashamed because of the myth of the Post Office's infallibility as a national institution, that their own flesh and blood had acted with malign and clandestine dishonesty. And that is a matter that has destroyed families in a way that can never be healed or compensated. But we come back to this annoying question, or those two questions that have not been answered. And again, before closing, and I promise you, sir, that this is my last submission, Tracy Felsted, Janet Skinner, and Seema Misra, against all the odds and against considerable opposition from all quarters, pursued Ground 2. And you will know, sir, from submissions I've already made, but also from the history of that case, that Ground 2 was bitterly opposed. And so it is, sir, that we respectfully submit that, notwithstanding the protestations to the contrary, what you have heard today is, again, part of the disconnect between rhetoric and reality. Returning very briefly to the historical shortfall scheme, the fact that Pol has published statistics that 75% of those claims have already been settled causes one justifiable concern given the manner in which it has previously approached this matter. And one wonders if there may need to be now a reopening of those awards given the penetrating analysis on behalf of Hudgels by Mr. Maloney about how the unrepresented can be, again, taken advantage of. So it is shameful, embarrassing, and beyond comprehension that those exemplars put before you by Mr. Maloney actually happened before lawyers came in to resolve the matter. And one asks, why is it so difficult? Why does it take so long to act with integrity? Why does it take so long to do the right thing, particularly since these people were subjugated? They were victims of effectively state power, an agency or public corporation that oppressed them, criminalized them, when they'd served that institution with loyalty, with kindness towards their customers, and with integrity. And yet they were degraded in that way and deprived of the means to clear their names. And it all started even before the very beginning. First, they were sloppy, they were slow, they were incompetent. It was all their fault. Then, of course, for that 1% or less who were subject to those latent bugs, errors, and defects and the remote tampering with the system, they were lying, dishonest thieves. And yet, year on year, as this irrefutable evidence built up, it was covered up, it was buried, and with it, the Post Office realized that they were burying them. And in conclusion, sir, if that is not taken into account, and if that is not amply and properly recognized and factored into the awards that are to be made, then this whole compensation scheme or schemes will not be fit for purpose. This is not benevolence. This is not Lady Bountiful giving alms. This is to restore people to the position they would have been and might have been, what they would have achieved. A bright 19-year-old, Tracy Felstead, who lost her entire adult life through the Post Office's malevolence. So you can't just give them a sort of mechanical or merely functional sum based on a box-ticking exercise. There has to be a qualitative assessment of these people's potential, the assets that they lost, and the opportunities that they were denied, all because of this malignant culture of secrecy and non-disclosure. And those two questions, unanswered, will continue to hang over the head of those who represent the Post Office, but more importantly, those who are the directing mind of the Post Office. And it is a profound shame to this country that even after all that has been done wrong, that silence, even today, persists. Those are our submissions, sir.
Can I just be clear about that I've got it right in terms of the persons whom you represent? Ms Felsted, Ms Misra, Ms Skinner and Mr Parek fall to be compensated under the overturned conviction scheme, as I understand it.
Yes, that is correct, sir.
Mr Castleton and Miss Arch will fall into the GLO scheme that Mr Chapman referred to this morning.
Correct, sir.
And Mr Shiju falls into the historical shortfall scheme.
Correct.
And is currently in the process of going through that scheme. So I've got 5.
Yes, sir.
Thank you.
Thank you, sir.
Thank you, Mr Henry. Yeah. Mr Steen, Mr Henry was correct almost to the last minute in terms of his prediction. I'm just a bit concerned about the shorthand writer. Would you like a short break before Mr Steen starts? Because I wouldn't want to interrupt him, and he's likely to be about the same length of time. Fine. Then we'll just have a short break, and then we'll resume with Mr Steen. Mr Steen.
So good afternoon. I will remain seated, as I have done through other submissions before this inquiry. And so, as you know, I represent, briefed by Howe & Co solicitors, 156 core participants, as well as supporting applications being made by other sub-postmaster mistresses and managers within the scheme. So one of the advantages, perhaps, of going last today, not that I can just, therefore, take the entire afternoon that's left, but
You certainly cannot.
one of the advantages is this. It's allowed us time to consider the various emails and contacts that we've had from clients that we represent, because they have been listening now that the live feed has been restored, and they have been taking account of what has been said by all of the parties that have made submissions before you. The summary answer from our client group as to what they have heard, rather sadly, is that they hear that next week or in the new year, things are going to happen, that these schemes will change, that there will be something being done about funding, there will be something being done about individual compensation claims. So as an example, Sinead Riley, who has been mentioned today by Ms Gallifant, her particular position is one that is very difficult. She wasn't, in fact, if you like, the sub-postmaster, but she acted as in the position of the sub-postmaster. And that was recognised at the time because the post office pursued a debt against her. Now, we hear today that her position will be addressed in the next few weeks. So the difficulty that our client group has in the responses that we've had so far today is that they only hear delay, sometime later, something will happen. They don't hear that work is ongoing. They don't hear about what has happened in the background. And so sadly, sir, we suggest that the product of what we've had today, through the compensation hearing that you arranged as part of this inquiry, has been, of course, useful, but not enough. Yesterday, we saw a product arising out of a lack of controlling mind across these compensation schemes. We had served upon us in the afternoon the proposed scheme for GLO members, the litigation group members. What we see as lacking in relation to the compensation schemes variously being discussed today is a lack of controlling mind, lack of cohesion, lack of intelligence being placed into these schemes across the board. We shouldn't be in a situation whereby essentially there are different choices and different types of systems being put forward in relation to people that have essentially the same issues as sub-postmasters, mistresses and managers. And of course, we represent people who are right now hurting. These are people that are finding it very difficult. And it's irresistible to say that we're looking towards a Christmas break or a holiday break, whereby people are thinking about how they can finance that and how that they can manage through that period. Now, the truth here is that the Post Office has fought and fought and fought to prevent the truth coming out and against the fair provision of compensation to those who have been harmed by this most public of IT scandals. My instructing solicitors, Howe & Co, have worked tirelessly with campaigners to shame the Post Office into recognising that they must compensate sub-postmasters. Regarding compensation, the standout issue that has bedevilled the provision of timely compensation for those that have suffered so much at the hands of the Post Office and BEIS has been the failure to make provision for reasonable financial costs of claimants so that they can have legal advice and representation. So we're not just talking about a couple of people who need help, but these are hundreds of sub-postmasters with complex, compound claims that can only be assessed and presented with the support of expert solicitors with experience in difficult compensation cases. It seems to us, and those we represent, that the Post Office and BEIS seek to wind back the clock and pretend, like Bobby Ewing returning from the dead in Dallas, from one episode to the next, that it was all a bad dream. So I'm sure you remember Dallas very well. The Horizon system was defective.
Don't tempt me.
So the Horizon system was defective. It's a reality. We suggest, as we're learning through the evidence in phase 1 and phase 2 of this inquiry, that the true extent of the losses to sub-postmasters, managers and their assistants are unlikely to be known for some time. We believe very strongly that we may so far have only seen the tip of the iceberg. It will be a matter for another time for us to assess and consider how much damage has been caused as we look at the range of factors which contributed to the shortfalls and losses seen by sub-postmasters. But it does seem very likely, from what we have heard in the evidence so far, that many sub-postmasters will not have understood that the losses they suffered and came to their door were not their fault, but the fault of the Horizon system. Let me then turn to the position of BEIS and the Post Office. And we should say for the record that part of the problem with BEIS and the Post Office is that they have no experience of engaging with and compensating victims. Ms. McMahon, who's an incredibly experienced solicitor who works at Howe & Co, she and I have discussed what is required. The client doesn't just walk in the door and then you say, right, here we go. You establish essentially a meeting with the individual client to set out what is going to happen. That then needs to be within the rules that solicitors comply by through the SRA, the Solicitors Regulation Authority, client care letters, letters that clearly set out a case plan, and letters that also deal with the question of how cost is going to be dealt with through the process. By the time that's happened and gone through, we're talking about an hour or two gone already of solicitors' time. What is happening, therefore, is that in terms of setting out the schemes that, as an example, we'll deal with it in more detail in a moment, under the GLO, there needs to be an understanding of what actually happens when you're dealing with people that have such complex needs through compensation. Unsurprisingly, we say, there may have been very few, if any, compensation schemes where the perpetrators call the shots and control the process. BEIS, we suggest, does simply not understand that traumatized people do not appreciate prototype schemes being placed on websites without any advance notice and without provision of the draft scheme to those who represent them. In light of these recent events, we say that you, sir, should recommend within an interim report that all schemes are overseen by an independent person with power to resolve disputed issues between the parties. A trusted individual, such as Lord Dyson, who has oversaw or overseen the recent neutral evaluation. The brutal reality is that notwithstanding progress that has been discussed today, and progress made mainly in relation to interim payments, sub-postmasters continue to suffer as they did in July. There has been a lack of progress where progress is most urgently needed. Now, so you are aware from our written submissions and from the file that we have presented to the inquiry that We have set out within those submissions and schedules many accounts of our clients, and I will not go through all of them. Nevertheless, whilst you have this material, this is a public hearing, and there needs to be a recognition on the public record of the ongoing harm caused by the Post Office, and so I will summarise. So in relation to the file we presented, you'll find this at page 2. I have it behind tab 1, but using the pagination bottom right-hand corner, which is consistent throughout the file, this is page 2. I will not read all of all entries, but parts of some. I refer to Peter Worsfold. He said in July he'd not been able to repay his 94-year-old mother. This month, December, he says that he has received interim compensation and it has helped pay some debts. He is concerned that receiving compensation in dribs and drabs means that he and other sub-postmasters cannot invest and receive income to look forward to an old age. He has effectively lost 20 years of business. Importantly, he instructs that the compensation he received did not touch the sides of what he has lost. Virendra Bajaj. My current financial position is worsening day by day, and the whole cost of living is teetering me off a cliff edge. I worry constantly how I'll be able to afford the bills. I can only pay off nominal amounts of the debt, and I've been told it will take me 100 years to pay it all back. Mentally draining, stressful, and exhausting. Robert Thompson. I've been fighting 5 years to get my name cleared. In that time, I've only had one payment, which was at the very beginning when this case was getting looked into. Does no one realise the financial strain you're putting on me and my family? Brian Wybrow. I feel that the inertia in the whole process is extremely frustrating, and alongside the ongoing inquiry, this just adds to the strain. Joanne Fulger. Christmas is going to be a struggle. Christmas dinner will be microwaved. Disappointment after disappointment is making a hole so big that I feel I'll never be whole again. Charlotte Ahmed, Faisal Aziz. We are worried if this winter we would be able to heat our home and serve meals to our large family at the same time. The interim payment we were given will only last a couple of months, considering the rising energy bills and inflation overall. He discusses his older children who have started to hide their needs. His 13-year-old daughter had a tear in her school shoe. She didn't tell us about it and decided to glue it in order to save money. Anonymous witness, or referred to by the last 3 digits 293. My experiences regarding the compensation process and claim submission have been difficult due to the length of time that has lapsed. It has caused mental stress. My financial pressures have affected my earning capacity, unable to work full-time and overtime as I used to. Applying for loans at high interest in order to get through this time and borrowing from friends and family members. James Withers. There appears to be no thought or compassion for the victims, from them and for how most of the victims are actually struggling. They seem to make it their mission to delay the outcome as much as they possibly can. Jane Bailey, the wife of a court participant, Lawrence Bailey. Our financial circumstances are we still have a mortgage on our property. Mortgage should have finished in 2021, and loans for the business. We're still paying out payments to the bank out of our pensions, and we are looking forward to the day when final compensation is paid. Only then will we feel it is over. Victor Price. I have for many years had mental health issues, and I'm not aware of until I had lost everything. We agreed to sell everything and just move into our caravan. This we did for 2 years. We've been renting ever since. We don't want charity, we just want some form of compensation to make up for the years we're paid in rent. Thomas Brown. The compensation process has been extremely unreliable. I was simply told that my case was complicated and they would be in touch. It once again left me in a state of financial difficulty. The government has agreed that the bankruptcy should be paid back in full. The only people in disagreement were the trustees. However, because I'm in such a desperate financial state, I had no choice but to accept the 51% I was offered. This had a detrimental impact on my mental health, as it dragged up all the past trauma caused by the Post Office over the years. Now, so later on I'm going to be referring to those of the 51% cases, the bankruptcy cases that have been dealt with like that. Thomas English. We were seriously abused by the management whose wages were contributed to by our investments. The fact that I, as a retired police officer and former Royal Marine, could have my reputation trashed by the management of a supposed organisation that was a pillar of the establishment. The thing really eats you up. The thing really eats you up. And it does so now, and I haven't had the suffering of others at the extreme end of this manner. And Donna Gosney is one of the many ex-sub-postmasters forced into bankruptcy solely due to the scandalous, damning and bullying behaviour bestowed on me by the Post Office. So, sir, those are some of the individuals, and there are others that are mentioned within that schedule. We mentioned that because we need to make sure that not just the inquiry panel, not just the inquiry team, but everybody understands that this is ongoing suffering that is happening right now, and we're talking about the need to deal with people right now. Take you now to the written submissions we have put forward on behalf of our client group, and turn please to pages 8 and 9, and coincidentally paragraphs 8 and 9. And I want to touch on Heather Williams' case. Paragraph 8 of our written submissions. The effect that Bayes and Poll's delay is having on our clients is starkly demonstrated, we suggest, by the case of Heather Williams. She spoke to Mr. Enright, my instructing solicitor, on the 1st of December of 2022. She told Mr. Enright that shortly after the announcement of the GLOW scheme, she was informed by Reith on a Friday that she would receive a significant sum by way of an interim payment. However, on the following Monday, she was told that she would receive nothing because she is in an IVA. Miss Williams' debt in respect to the IVA is less than £2,000. Miss Williams has very little money. Her accounts with her electricity and her gas providers are £2,000 in arrears. She's worried that her power will be cut off. Consequently, she doesn't heat her home. She often eats pot noodles. 3 weeks ago, Miss Williams had a bad fall at home because she was tired and weak, not from having eaten, from not having eaten. During this time, she says she was in so much pain, cold and hungry, and all alone. She was unable to get up from the floor for over 2 days, and she finally managed to crawl to where her phone was, but it was out of charge. Luckily, she could get to a charger, and she was able to call for an ambulance. She remains in hospital. She is desperate to receive an interim payment, which she believes would sort out all of her problems, and she still received no compensation. Sub-postmasters need and deserve the support of competent solicitors such as Howe & Co, and where required, advice from counsel and input from medical or other experts in order to present their cases in the best possible light, and they should not have to do it on the cheap or be forced, as they are now, to go cap in hand to the perpetrator for some type of time-to-time funding. Further, we say that all sub-postmasters, whether within the historic shortfall scheme, the overturned historic conviction scheme, or the group litigation scheme as proposed, should be entitled to aggravated damages. And so you will be very familiar with the case law, the 1972 case of Bruno versus Castle, where aggravated damages were considered in relation to the following context: the high-handed, malicious, insulting or oppressive behaviour that would justify going to the top of the bracket in terms of damages and awarding as damages the largest sum that could be fairly regarded as compensation. Or the judgment of Mr. Justice Pomfrey, as he then was, in Nottingham Healthshire case against News Group newspapers in 2002, where frankly he could have been referring to a situation as we have heard in the human impact hearings. He put it this way: an award of damages, while awarded with a view to compensating the claimant for his loss, has regard to the injury to the plaintiff's proper feelings of pride and dignity, humiliation, distress, insult or pain caused by the circumstances of the defendant's conduct. And we suggest, sir, that the situation of the sub-postmasters and mistresses who fall to be compensated fall within that very highest bracket. We often hear representatives of the Post Office and BIS say the words that they are sorry on behalf of their client organisations. They do it in well-delivered apologies when they have to. But we suggest that the way that those organisations have treated compensation and support for sub-postmasters make those apologies seem empty and bereft of compassion. In summary, and despite what has been said by the Post Office and BEIS in their written submissions and orally today, the current situation is this. There is no agreed scheme for the provision of compensation for those maliciously prosecuted. We have heard today that those who were prosecuted but acquitted will be dealt with within the schemes, the GLO scheme and the people who have been prosecuted scheme. Even after yesterday's manoeuvring in relation to the proposed GLO scheme, there is no agreed GLO scheme. This is what has been set out by government. And the original HSS scheme is questionable. We'll remember the submissions that you heard going now back in time when we were also, I think, able to watch the beginnings of a cricket game. There are windows across the place we were sitting at the time. That the HSS scheme is questionable at best in the way that it sought to minimise compensation rather than ensuring that ancillary losses for pain and suffering are identified and provided for. Now, this has all been hugely frustrating for those who are trying to help the victims here. Howe & Co have worked tirelessly, I suggest, on these areas and have endlessly corresponded with Pol and with BEIS. But that firm, my firm of solicitors, Howe & Co, have not received a penny from Pol or BEIS for the work associated with attending meetings, canvassing their client views and making detailed submissions at BEIS's request. Now, the issue of funding for solicitors never sits well with making submissions when you're talking about compensation. But with this number of clients, firms such as Howe & Co must be funded to have at least parity of ability to make representations on parts of their own of the cases or the cases that they represent. But on the other hand, of course, when Post Office and BEIS reply, they do via their lawyers or via their team members, pay for out of their payroll, or instructed solicitors assisted where needed by counsel. On the 17th of November of this year, the Minister announced that BEIS had spent 53.4 million on legal and administrative costs for the HSS to date, with 7 million spent and 31 million projected to be spent on legal advice on the overturned conviction. There is, we suggest, strong evidence from that, if nothing else, that what is going on here is a clear inequality in arms. Yesterday, and confirming that the only way that the government, in whatever guise, BEIS or its wholly owned subsidiary, the Post Office, reacts to this continuing scandal, we had the announcement from BEIS and the Right Honourable Grant Shapps MP standing up in Parliament stating that the GLO scheme had a particular shape. Never has there been a better illustration that the inquiry cattle prod touching the backside of the state is the only way that progress is going to be made. Now, we know that the intention behind this announcement is that the members of the GLO will have a scheme which will enable them, I quote, to receive similar compensation to their peers. This will require a calculation of their losses and damages in just the same way as is required for those who are being dealt with under any other of the frameworks or proposed frameworks. Just as an example, Ms. Mann, who I've mentioned earlier, an experienced solicitor at Howe & Co with experience of individual claims. She started to look at what might be required for any individual case and tried to start putting it together so that she would have an example of what may be needed. Well, putting aside the starting point, which is client engagement letters, conversations at the start. So far, in relation to one example, it led to something like 400 pages of disclosure from the Post Office. Those include call logs from EPOS, the EPOS part of the system when working as a sub-postmaster. It includes consideration of the shortfalls. The reason why you need the call logs is because you need to argue what the shortfalls are and they need to put the two together. HMRC records is something like 20 pages. GP records, 100 pages. That's without essentially starting the case. That's just gathering the materials. The Minister's press release yesterday states that what we paid is £900 per claimant to prepare a claim. Covers, we think, something approximately like something in the region of 2.5 hours. This will not cover client conferences, reviewing disclosure, taking a proof of evidence, investigating, supporting the claims, preparing instructions to experts, preparing schedules of loss, etc. And this will not be sufficient for the instruction of counsel to provide an advice on quantum. It would assist, sir, and it would assist this inquiry, if you had clarity on payments of costs thus far to Herbert Smith Freehills. And so you may find also useful information from Frees, who've referred in their letters to government costs. Then just after 2 p.m. yesterday, Howe & Co. was sent the email from Mr. Brightwell signing itself off as GLOW Compensation Department for Business, Energy Industrial Strategy, which now sets out that the £900 is an initial allowance, apparently determined by a cost draftsman, with further cost allowance for the remaining phases up to, including submission of claims to be published in the next few weeks. So we move on from £900 as a starting point to now this is an initial amount, an initial allowance, and then further applications are going to need to be made in order to make progress with the proposed GLOW scheme. So it's going to be worthwhile just for a moment to compare the announcements from BES yesterday with the correspondence from the Post Office this week. So you should have before you a letter dated the 5th of December. I'm very grateful. Now, the letter is from the Post Office, dated the 5th of December, top right-hand corner, in correspondence, thanking Howe & Co. solicitors for their letter and correspondence of the 27th of November. This is titled Compensation Claims, and then references to thanks for participation in meetings and the like. Third paragraph. From Mr. Rakuldin, the Director of Historical Matters, Post Office Limited. We do not believe that your various comments regarding the payment of reasonable fees in respect to of these matters claims is correct. It has always been the position that Post Office will meet the reasonable costs in relation to the compensation claims. Our only concern is the question as to what is reasonable. You are correct in that it may indeed be in the best interests of the sub-postmasters that a set of defined fee parameters be agreed within the framework of the compensation process, so that there could be clarity in this regard. We would therefore invite you to provide us with a breakdown of your proposed costs, so that we may open a dialogue and work towards an agreement in respect to this issue. The one thing that we all agree on is the principle that people within the GLOW proposed scheme, GLOW claimants, be put in the same position as the other claimants with identical claims arising out of the scandal. Yet the Post Office and their owners, the department they report to, BES, are suggesting that representation and reasonable payment for fees should be allowed for in two different ways. One, tranche by tranche, on application for each part as you move forward, and the other, it seems, by an acceptance of reasonable fees, yet to be agreed within a framework. Now, this is either the Post Office or BES deliberately treating the GLOW litigants less favourably than other SPMs who fall to be compensated, or it shows that the left hand still does not know what the right hand is doing. Either way, this gives the impression of chaos. That chaos hasn't lifted since we were back here in July, and so that is one of the good reasons why we need an interim report. There is nothing new or magical about legal costs. Hourly rates are set by the court, and in any civil litigation, if costs and disbursements are not agreed, they'll be subject to taxation by a costmaster or judge. It is perfectly standard for there to be a final independent arbiter on costs issues, rather than the defendant keeping the matter to itself, doling out sums where it says and exercising total control. Let me be clear. Howe & Co. and the other firms acting on behalf of sub-postmasters are well-known firms who are very experienced in acting on behalf of claimants in civil proceedings. They know what needs to be done. They know what sort of costs will be incurred, and they are used to the cost taxation process. We are not seeking to reinvent the wheel. We merely seek some level of parity of representation with the Post Office and BES. Simply put, fairness for sub-postmasters. May I then refer, please, to the complex cases, those that have been made bankrupt and IVA clients. It is absurd that some of the most vulnerable victims of the post office are languishing at the back of the queue. There should be no queue. Where cases are complex or involve bankruptcies or IVAs, BES should divert resources to dealing with those problems rather than sidelining them. The unfeeling as he said it, the unfeeling that has been that has characterised the last few months must end. Another reason why the bankruptcy cases should not be sidelined is that it was the actions of the Post Office that bankrupted our clients. Mr. Shapps in Parliament yesterday, in the points that he was putting forward as he was addressing the introduction of the GLOW scheme, accepted that there were those that had been bankrupted by the Post Office. Those actions in bankrupting or turning to an IVA, those individuals are part of a truly shocking public scandal. And the clear duty of the Post Office and its owner BES is to clear the debts, restore the credit ratings of sub-postmasters so that it can begin to live again. Just as a personal aside, a couple of days ago I was sorting out some my own insurance issues that left to be dealt with and finally got around to. And one of the things that struck me was the question that I was asked: had I ever been made bankrupt? The answer is no. One of the problems with bankruptcy is it acts a little like a conviction. It remains a stain on your character as you try and move forward and try and gain credit. Now, so you're aware of individuals in the position of Mr. Sethi. You can see that in relation to the details that we've set out in the Howe & Co submissions at page 12, paragraphs 18 to 23, you'll remember his powerful testimony that you had before you on the first day of the human impact evidence on the 14th of February 2002. Pol still has failed to progress Mr. Sethi's claim or pay any compensation to him. Must he, as he said in his evidence to you, die before any compensation is received? Ms. Sue Palmer's case is a double whammy, and you'll recall her position that BES originally refused to implement your recommendation on providing compensation for sub-postmasters who had been prosecuted and acquitted. Now, in respect of the GLOW scheme, her position is set out, amongst others, at paragraphs 24 to 33. BES suggests that the way forward is for her compensation to be paid 51% to her and 49% to Moores, the administrators of her bankruptcy. And so I take you to the bundle, if I can, please, again. Just briefly, if you'll go to page 14 of the bundle, bottom pagination, bottom right-hand corner, you'll see this is a letter dated the 30th of November to Laura Pickering and Moores, the trustees in bankruptcy. Hi, Laura. Is there still no update? Please put me out of my misery. I need to know one way or another. Tomorrow is the 1st of December, 25 days till another miserable Christmas. Page 12. Thursday, December the 1st, 2022, 11:02. Message from Freeth Solicitors to Ms. Palmer. Dear Globe Postmaster, etc. So this is a response from BES in relation to her position, and the third paragraph tells us what is being suggested. From BES, we recognise the need to get you some money quickly, and so we plan to agree to monies being paid to you in line with the terms of the original assignment. You would receive the portion of the interim payment which relates to your personal losses. We will confirm with Moore whether any of the initial £11,000 fee is outstanding in each of your cases. Of the remaining amount, you would receive 51% and Moore would receive 49%. This decision only relates to your interim payment. How payments are treated under stage 2 of the scheme are yet to be determined. Page 11. Ms. Pickering, again from Moores to Ms. Palmer. Dear Suzanne, no update at the moment, unfortunately. However, we are having a call with BES on Monday to discuss this matter further. And seeing the emails in relation to this subject today, nothing further has happened. That remains the basic position. can we, on her behalf and on behalf of those others that are stuck in this, this logjam in relation to these bankruptcies, can we ask why? Why is the suggestion that the compensation to Miss Palmer will be split between her and her trustees in bankruptcy? Of course, we know the answer as lawyers, that as someone registered as a bankrupt, her administrators manage her finances and are appointed to use monies that comes to her for the benefit of her creditors. But the Post Office and BES put her there. What must happen is one of two choices. For Miss Palmer and others in her situation, they must be funded to pay for legal representation to annul their bankruptcies, as because of the highly unusual circumstances of her bankruptcy, the bankruptcy order should not have been made. Or all her debts and bankruptcy fees must be paid or secured, in other words, guaranteed, by a third party, BES and POL. And her bankruptcy must be annulled in order for her to be able to move forward without that hanging over her head as a registered or previously discharged or discharged bankrupt. Of those in an IVA, their debts must be paid by BES and POL and the IVA discharged. The notion of Miss Palmer's compensation being split is unreasonable unless it can be assured that for the present purposes, her part of the split to the administrators will never count against her or be deducted at a later stage from her overall compensation once BES and Post Office has settled the bankruptcy. So we are aware of the difficulties that the position of those that are in this situation pose to the Post Office and to BES. But the position is, in fact, to a large extent, illusionary. These individuals have been known about for some time, and we are here discussing this on the hearing that you have convened to consider what is going on just before Christmas 2022, so long after these events have taken place. If they've caused it, they need to solve it, they need to resolve it, and they need for these individuals to be able to move forward and be paid. Now, we've had discussions in the margins of these hearings today with Mr. Brightwell, and I know that he is willing to meet and try and discuss the individual circumstances and try and find a way forward. And we know that essentially there is a will to pay, but the will to pay must be a will, I'm afraid, to pay those individuals more than they might get otherwise in order to find their way through these bankruptcies. What must not happen is that their compensation should be split for something that has been at the cause of Post Office or BES. So, we suggest, sadly, the Post Office and BES have created chaos, and that is adding to the suffering. There is a need for an urgent interim report from you, sir. The situation of so many of our clients is intolerable. BES has had a chance to resolve matters in July, but it did not take that chance. Now, sir, we've not had sufficient time to evaluate the details of the prototype scheme that's been put forward. We do note that in relation to this scheme that there are various issues. So very briefly, I don't know whether you have this to hand, but I can read it if not.
I think I may have it to hand.
Very good. So I'm dealing with the document that was provided, served yesterday, described as being the additional compensation for GLOBE members scheme process.
Yeah.
Paragraph 13. The taxonomy will need to pay special attention to cases where technical difficulties can be expected, such as bankrupt or deceased claimants, company claimants, claimants whose partners are also claiming under this or other schemes, or claimants lacking capacity and no legally appointed representative. Also, that's the mention of those individuals in those particular positions. In other words, we'll work it out sometime. Now, within this, if you then go, please, to the references at page 21.
Page or paragraph, Mr.
Page, please, sir.
Page, right, fine.
Bottom right-hand corner, pagination, page 21.
Yeah.
Consequential loss claims. The panel should apply the scheme consequential loss principles and guidance which are included at Appendix 1. Also, there is no Appendix 1. The review and approval at paragraph 36. The version of the terms of reference was approved by the Historical Remediation Committee on June 20th, 2022. So we know that this is a cut and paste document from earlier schemes that have been put forward. We know that because if you go to page 22, you can see the heading is Historical Shortfall Scheme, Consequential Loss Principles and Guidance.
Sorry, there's something. I'm not. My page 22 is headed Consequential Loss Claims,
Yes, sir.
and my page 23 is headed Historical Shortfall Scheme. I just want to be sure I'm in the right place, that's all.
It may, yes, it's being suggested it may just be the way it's been printed off.
Yeah, quite possibly.
So, yes.
So could you just go back to the... You made a point about...
Yes, sir. Well, the way we have it...
if you give me the paragraph number, I think...
34, sir.
34, right, hang on. The panel should apply. Yeah, fine.
The consequential loss principles and guidance
Yeah.
are included in Appendix 1.
Yeah.
There is
and
no
there is
appendix.
no Appendix 1. Yeah, I've got that, yeah.
If you have paragraph 36,
Yeah,
the version of the terms of reference was approved by the Historical Remediation Committee on 20th of June 2022. And then if you turn over the page, you then see the Historical Shortfall Scheme, Consequential Loss Principles and Guidance, which I strongly suspect is what in fact is meant by Appendix 1.
yeah.
But if you then glance through the number of pages that refer to consequential loss and the principles applied, which then takes us through from page 22 to page... Yes, it goes to page 31.
Yeah,
Glancing through that, sir, you will see, which from so your own work in the past, these are the principles set out for pain and suffering, loss of immunity that we will find if we were to turn our minds to it. These are complicated matters that require considerable attention to detail. They require individuals to have representation that can cover these details from the earliest possible stages of meetings. Reasonable costs must be paid. All our clients are actually asking is that, bearing in mind they've waited decades to receive fair treatment, they want the ability to instruct solicitors to process their claims in the normal way without having to go cap in hand to the perpetrators of this scandal. Now, sir, we've set out in detail, and I won't repeat orally, the recommendations we sought in our written submissions.
yeah.
They concern the resolution of the complex cases or bankruptcy issues and the like. So let me now turn, just very briefly, to restorative justice.
And this is your page 33 of your written submission.
So, yes.
Yeah, right.
Now, in the same letter that I've referred to you a few minutes ago from the Post Office, the current position as regards restorative justice is that the Post Office suggests that they can be left to deal with meeting arrangements with sub-postmasters, our clients, and that solicitors are not required. Unfortunately, we have to say that the Post Office simply has not been listening to our clients in the Phase 1 hearings. Ex-sub-postmasters, mistresses and managers don't trust the Post Office, and for very good reason, with the way that they've been treated for so many decades. The years of denial of responsibility throughout those last 20 years are a good reason for the lack of trust, and as we suggest, is the hurt from the continuing response to compensation issues. All our clients want is to them to have their lawyers, who they do trust, discuss terms for restorative justice with the Post Office and for their lawyers to be paid reasonable costs for doing so. They should not have to be made to do otherwise. Now, we have also suggested at page 34 of our written submissions how restorative justice might look, including such an idea as an entrepreneur's fund for and bursaries for the families of sub-postmasters. Our clients' lives have been torn apart. They started businesses that they expected to see them through into their retirement looking after their families. Children that would have been brought up within sub-postmaster branches and offices where they'd been learning the value of small businesses, often torn apart by the actions of the Post Office. Restorative justice is also about making sure that in this particular matter, that the Post Office has actually learned lessons And so far, rather sadly, it seems that the post office hasn't even started at school. So enough is enough, sir. We suggest that there is a need for an interim report under Section 24(3) of the Inquiry Act, and that, so we ask you to carry through the intention, well, the suggestion that you made that you may do. Two last points. We ask that the process of compensation hearings in this inquiry continues. We know it seems that it's the only way to make sure that anything is done. And I join with Mr. Maloney in his submissions, which is to ask the inquiry to ensure that it is able to continue oversight through its hearings of these hearings, in these individual hearings of the compensation process as we move forward. Second point. You've dealt with this largely by discussing matters with Mr. Maloney regarding convictions and the progress of matters being dealt with at the Court of Appeal. I agree entirely with what he said. I'll just add one small point. The way that the Court of Appeal is dealing with matters, sir, for your information, is that when sub-postmasters or individuals come to them who are caught within this, within this particular scandal, the Post Office the Post Office isn't, the Court of Appeal Registrar's Office is contacting solicitors that have acted on behalf of those individuals in the past and are ensuring that they have representation. And we then go through the process, either Ms. Maloney or myself or our teams go through the process of considering the information, advising as to whether there is in fact a potential for the appeal to go further, and then putting forward grounds. So there is a process, and it doesn't involve the CCRC. So forgive me for one moment. So nothing else. Thank you, sir.
Thank you. Right, I think that concludes the oral submissions to supplement the written submissions that I've received. I'll go away and think about them and decide what to do about them. So there we are.